A very good afternoon to one and all present. On behalf of Clue for Evidence Foundation and Chairman, I, Falguni Oja, welcome you all to DHI 39 Expert Talk on the topic Legalities in Admissibility of Digital Evidence. We have with us Professor Mamta from C Law College, who is the co-host of the session. I welcome her and I welcome our speaker of the day, Mr. Na Vijay Shankar. Now, I would like to request Mamta ma'am to kindly introduce the speaker of the day.
Yes, thank you. Very good afternoon to all. Warm greetings from C Group of Institutions and Clue for Evidence Foundation, Bangalore. I am Mamata, Principal of SEA Law College, and today we, the strong wing of C Group of Institutions, that is C Law College, in association with Clue for Evidence Foundation, is jointly organizing this webinar on the topic Legalities in Admissibility of Digital Evidences, with a view to provide information relating to digital evidences, data protection, and the cyber related aspects, as it has become the need of an hour. In the present context, all of us, we are very much well aware due to the impact of the pandemic, COVID-19, on the entire globe, which has really made everything to go with online through the medium of digital and electronic device to maintain social distance for the healthy society. So, in connection with that, in order to fill the gap and meet the needs of the society pertaining to the sharing of knowledge and digital evidences, as well as to check the legal validity of evidences in the court of law, this webinar is being organized for the benefit of whole society. Now, it's my proud privilege to welcome the speaker, the eminent speaker of the day. Now, we jointly, the C Group of Institutions, the C Law College, and Clue for Evidence Foundation, extend a warm welcome to our distinguished jurist, a distinguished speaker of the day, Sri Na Vijay Shankar, who is well known as Navi, and who is IT and law data protection consultant, as well as the guest faculty of National Law School, Bangalore. We would welcome you, sir. We would like to extend a warm welcome to you, sir. Now, I also welcome our management of C Group of Institutions, the chairperson, Srimati Manjula A. Krishnappa, who is the chairperson of the C Group of Institution, Sri D.T. Srinivasa, who is the secretary of C Group of Institution, and Srimati Purnima Srinivas, who is the CEO as well as sitting MLA of Hiriyur constituency, and Srimati K. Anupama, joint secretary, and Mr. Brijesh Yadav, Vinisha Yadav, and Rohan Yadav, as well as and our most eminent person, Professor V.N. Rao, who is the former Vice Chancellor of Acharya Nagarjuna University and the Director of C Group of Institution presently. All of you are welcome to this event, sir. Most importantly, further, I would like to introduce one more personality, and I would like to extend my warm welcome prominently, most importantly and prominently, on behalf of our C Group of Institutions. We extend a special welcome to Mr. Panindra B.N., Director and a Court Commissioner of Clue for Evidence Foundation, as well as eminent advocate, and he is a forensic expert too. We welcome you, sir. I, on behalf of C Group of Institutions as well as Clue for Evidence, we heartfully extend our welcome to all the legal fraternity, academicians, research scholars, students, and all the participants to this event. We welcome you all. Now, proceeding further, I would like to introduce our speaker, Sri Na Vijay Shankar, who is known as Na Vijay Shankar, and a well-known personality. It is my proud privilege to introduce Na Vijay Shankar, who is also called as Navi, who is a data governance and data protection consultant who is eminent personality and the speaker of the day. It is my proud privilege to introduce Sir to all of you, who has specialized in regulatory compliance in the areas of ITA, as well as he has over 40 years of domain expertise, including banking, advertising, cyber law, education, information, and data security compliance. A largely self-developed professional, qualified as a postgraduate in physics, banking, certificate in banking finance, as well as a postgraduate diploma in management, he has created own educational certification programs through Cyber Law College on certification in cyber law as well as in privacy laws in India, which are very, very prominent in the present context. He is also a visiting faculty in a number of premier legal institutions in the country. He has pioneered, he is a pioneering provider of several techno solutions for legal compliance, as well as he has presently focused on a new project in data governance relating services, namely data governance trustee. And he has also pioneered several academic thoughts such as theory of information, security motivation, and theory of data, etc. Now, working on developing a data on how the classical cyber law thinking needs to be modified consequent to the emerging technologies such as artificial intelligence and quantum computing. And he is also pioneered the concept of personal data protection standard of India. He is also authored a book titled Personal Data Protection, etc. So if you keep on reading his profile, it's an enlarged one and enormous one, and it is my proud privilege to really talk about sir, and we are welcome you, sir. I am very much blessed to go through your profile and highly appreciable, sir. Please, you are welcome, sir. Go to you, sir.
Thank you, thank you.
Over to you, sir. Over to you, sir. Please.
Yeah, I hope I am audible and my screen is visible. Okay, fine. So of all the things which you suggest, which you use for introducing me, only one thing which is relevant, which is when it comes to the presentation of cyber evidence in a court of law, I was involved in the very first case in which conviction occurred in India under Information Technology Act. That was the Suhaskati case in Chennai. And that was also the first case in which cyber evidence or digital evidence was presented under a section 65B certificate for the first time in the country. That was in 2004. So that is more relevant as far as today is concerned. Then we will now go ahead with this today's agenda of discussing legalities in admissibility of digital evidences. Now, for today's discussion, the issues we need to discuss are: one, what is admissibility? Is it different from a discussion on genuinity of the evidence? Second, whether electronic documents are recognized in law. If so, what exactly is the electronic document by definition? Then, are electronic documents recognized as evidence under Information under Indian Evidence Act? Then, is electronic evidence same as a oral evidence or a documentary evidence for evidential purpose? Then, is there a primary and secondary document concept in electronic documents? If so, what is the difference? Then we'll come to what are the conditions for admissibility of electronic documents as an evidence under Indian Evidence Act. This
Madam, thank you very much for your introduction about me, and I'm happy that you have started with the webinar series, and I welcome all the participants for the discussion on one of the most significant topic, that is forensic science in crime and criminal investigations. So with all the regards to the organizers, I start my session for the day with a brief note.
Okay, I think I will continue. So these are the issues which I have taken for today's discussion. I understand that a lot of the participants are law students. There may be others also. And many of you may be experts in evidence law separately. But I would like to focus my discussions basically on the electronic documents. Now, this question of admissibility and genuinity is the first thing let us address. This was addressed in the Supreme Court judgment in the case of P.V. Anwar and P.K. Bashir, where the Honorable Supreme Court stated that evidence is constructed by the plaintiff and challenged by the defendant, and construction is through pleadings and proof is through evidence by relevant and admissible evidence. Genuineness, veracity, or reliability of the evidence is seen by the court only after the stage of relevancy and admissibility. So we are discussing today this admissibility under section 65B as the first stage of establishing the evidence at the stage of admission. Subsequently, it doesn't mean that whatever is admitted will definitely be carried through as genuine. That is a different issue. So let us keep this difference. In our law, there is a distinction between the admissibility and examination of the genuinity. Now, admissibility includes two aspects. One, electronic documents should be first of all recognized as equivalent to, let's say, a paper document. Then we have to establish that there should be a process for admission. So there are two aspects: legal recognition as a document, as an evidence, and then go into the procedure for admission. Now, if you look at legal recognition of an electronic file as an electronic document, there are certain provisions under Information Technology Act. There are also provisions in Indian Evidence Act when it comes to recognition of a document as an electronic evidence. Under Information Technology Act, there is one section called Section 4, which says that wherever any law requires a document to be in writing, that requirement is fulfilled by the document expressed in electronic form. So Section 4 creates a recognition for electronic documents as equivalent to paper documents in any law. Therefore, the question comes that if paper evidence is there in electronic evidence, should then the electronic document be equated to the documentary evidence in the Indian Evidence Act? Information Technology Act also talks about digital signatures, equivalence of digital signatures to the method of signing, and there are digital signature and electronic signature. So Information Technology Act looks at legal recognition of the document as a whole, then the way of authentication, and electronic evidence related issues are considered in Indian Evidence Act. There we have got multiple sections which we have to look at. Section 3, 17, 22, capital A, 59, 65, capital A, and 65, capital B. Let us look at these sections individually to understand what does the law in India state about the admissibility of information which is in electronic form. As far as Section 4 of Information Technology Act is concerned, it talks about rendering a document in electronic form, which itself, if you look at other aspects of Information Technology Act, you will understand that a document in electronic form is a document which is something which can be expressed in binary language. If there is anything which can be expressed in binary language, that is what qualifies itself to be called as an electronic document under IT Act, because this Act specifically uses a representation of information by manipulation of electronic, magnetic, or optical impulses. The use of the word impulses in Information Technology Act is very much important for us to recognize. And the impulse can be an electronic impulse, which is what we do in chips, okay, where electrons are moving from one side to another, and it is blocked at a particular point, and say no electrons is one state, electrons gate is open, that is the second state, that is 0 or 1. It can also be a magnetic impulse, which can say there is a magnetic charge, there is no magnetic charge. It can be an optical impulse, as in a CD, where you send a light, light comes back, or light doesn't come back. You know, in the CD, we have what is called lands and pits, a flat surface and a pit. When light goes into a flat surface, it gets reflected back. When it goes to the pit, it gets dissipated. So one is called 0, another is called 1. So that is how data is represented in computer environment through manipulation of impulses. That is the definition in Information Technology Act, which leads us to the conclusion that binary expressions are the one which are called electronic documents in Indian law. Of course, Information Technology Act has got a separate section which says that certain instruments are not coming under Information Technology Act at all. They are excluded from the Act. Such exclusions are applicable to negotiable instruments other than the check, which means your bill of exchange and promissory note, a power of attorney document, a trust document, a will document, and also the document which transfers title in an immovable property. Now, these are excluded documents from Information Technology Act. They are therefore excluded even from Section 4. Therefore, they are not legally recognized under Information Technology Act. So, therefore, the question of such electronic documents becoming evidence of electronic nature is doubtful. We should consider that these cannot qualify as electronic evidence also. Now, Section 5 talks about the equivalence of digital signature to wherever else we think a signature is required in form of authentication. And there are different ways of, two different ways of such authentication. One is explained under Section 3, another is explained under 3 capital A, which is the e-sign, which we are presently using it. Now, in the case of civil proceedings, you can have an electronic document which can be considered as equivalent to a paper, and if it is digitally signed, you can call it as a signed paper. If it is undigitally signed, it is like an unauthenticated paper. It is something like a paper on which no signature is there. And in accepting it for evidence, we may be saying that if it is digitally signed, I will accept it, otherwise I may not accept it. In criminal proceedings, sometimes it may not be possible for us to insist that we will take evidence only if it is signed, otherwise we will refuse. There, the consideration may be different. Now, when we come to the evidence, the Indian Evidence Act under Section 3, which was, of course, amended when Information Technology Act came, has made a statement that evidence means and includes electronic records produced for the inspection of the court. The definition of electronic records used here is part of Information Technology Act because all these amendments were done as a schedule to Information Technology Act 2000, so they go together. Now, if electronic record is a document expressed in binary notation, then the same thing is also applies to the electronic evidence, and such document can be either a text or an audio or a video, but all these documents are binary expressions containing a stream of zeros and ones. So whatever we call as electronic document, electronic record, or electronic evidence, they are all just a sequence of zeros and ones. This is the fundamental principle we have to absorb in our mind before we look at the legality of the admissibility of evidence. Now, when we come to Section 17 of Indian Evidence Act, it says an admission is a statement which can be oral, documentary, or contained in electronic form. This was added as the amendment. Now, what we have to observe here is this considers three kinds of statements. One is called oral, another is called documentary, and there is a third category called statement contained in electronic form, which for some reason, which we feel done deliberately, has been kept different from documentary. Therefore, today we have to look at three kinds of statements: oral statement, documentary statement, which is the normal paper-based thing which we are accustomed with, and the new thing which has come, which is the statement contained in electronic form. So there are three kinds of statements, and we have to look at this Indian Evidence Act to see how does a oral statement can get admitted, how does a documentary statement can get admitted, and how does an electronic statement get admitted. So there should be provisions in the Evidence Act for all the three things separately. We should also look at two other sections before we go into the admissibility of the section 65B. One is 22 capital A. What this 22 capital A says is oral admissions as to the contents of electronic records are not relevant except in a specific situation, which means that while we have said that there are three kinds of statements, oral, documentary, and electronic, then the Act goes on to say oral admissions are not relevant to electronic records, so please keep it aside. We will eliminate that. Then again under section 59, it also says that all facts except contents of documents and or electronic records may be proved by oral evidence. So there is a distinction of oral and the electronic records very clearly in these two sections, 22A and 15 and 9. So which means that oral form of admission of an electronic document is not permitted except in this situation which has been earlier stated, unless the genuineness of the electronic record produced is in question, which according to the Supreme Court is the second stage of trial in a court of law. So at the admissibility stage, there is no oral statement which can be presented for proving or disproving an electronic evidence. Now, when we look at the electronic evidence, let us take one example. Say, an electronic evidence is a sequence of zeros and ones. Now, let us say a petitioner presents what is called or referred to as the original evidence, and it is in the form mentioned here 0, 1, 0, etc. Now, this is the binary notation which the computer can understand, but humans cannot understand. So, if you place it before the judge cannot read this and take it as evidence. So, what should he do? He will ask some expert to come and interpret this electronic data, and that expert can recognize it either as the first one which I have written. He can look at this thing and say after every 8 digits of zeros and ones there is a space. So this person may interpret that each should be considered as a distinct entity, and therefore he will read it as 84, 105, 114, 117, 112 like that. Now there may be another person who may come and read this. He will remove all the spaces and read this from 0 from the first to the last this thing, and he will come up with a number which is given here 608 something something, okay? And a third person may come and he will read this in his own form, and he may say this means Tirupati, okay? And another person may say, yes, I agree it is Tirupati, but it is written like this, which is a different language rendition. Now, which means that for this electronic document, now I have got 4 versions of human, you can say, interpretations, starting with a sequence of numbers 8405 to one single number, one big number, then Tirupati in English, Tirupati in Kannada. So there are 4 different versions, and if you ask that expert to give a certificate to the court or give a statement on oath, each person will give a statement on oath that what he is telling is true. The question is, all these 4 people may be saying the truth, but the judge wants only one truth. So this is the dilemma of the judge in accepting electronic evidence, where the original electronic evidence is a sequence of binary digits, and whatever people are talking of everyone is only talking of an interpretation of the original binary expression, and this interpretation depends on what software and hardware the person has used. If a person has used a converter of binary to a number, he will come up with a number. If he uses a binary to ASCII text conversion, he will come up with Tirupati. Or if he is using a converter which also has a language converter, then he will come up with Tirupati in Kannada. So therefore, this opinion about what an electronic document is dependent on the devices which are used for converting the binary into a human readable, you can say in this case a text. Okay, same thing applies to an audio and video. You may have an electronic document which is zeros and ones. You put it in a media player, it will show on the screen some picture, or it will send some noise or sound through the speakers. That depends on whether your computer is capable of interpreting this sequence as an audio or as a video. If you do not have a video player, if you try to read a video file in your Microsoft Word, obviously you will not get anything sensible out there. Therefore, every interpretation of an electronic document by a human being is relative to the process which has been used for converting the electronic document, which is a sequence of binary, into something which humans can understand, which means that the six senses of humans can grasp by our eye, ear, or both together. In future, we will have sensors which can transmit smell and touch also through computers. Maybe at that time we will have an electronic document which will give you a certain kind of a smell or a touch sensation. So this human experience of an electronic document is dependent on the intermediary devices. Therefore, when this court is trying to appreciate an electronic document, the court has to understand that there is no one single meaning to an electronic document. The meaning will be ascribed depending upon the various devices. Now I have to find out one sensible person who will use some standard method and gives a certificate saying that this 0 and 1 means Tirupati if I use this kind of a process. That is, I put this binary document in a computer, I will read it with a binary text reader, and that binary text reader is configured to read it in English. Then I get this something called TIRUPUTI. That is what I consider as this evidence which somebody is showing. So this appreciation of electronic evidence cannot be done in absolute terms. It can only be done in relative terms. This is the essence of the appreciation of information in electronic form, and this has been effectively captured in the section 65 capital A and 65 capital B. Today, if you want to look back at Information Technology Act, this introduction of 65B in Indian Evidence Act through the Information Technology Act is the master stroke of Information Technology Act, because this has really helped in electronic evidence being brought to the court and being made admissible in a court of law without undue complexities which are otherwise inherent in appreciation of electronic evidence. Later on, I will try to discuss a few cases where I will try to explain why I say so. So now, if we look at this section 65 capital A of evidence, I used the term capital A because sometimes people try to misunderstand 65 small a, which is a subsection of a particular section. with this 65 capital A is an independent section. It is not a subsection of section 65. So this section says it is special provisions related to evidence relating to electronic record. By the time we come to section 65A, we have already eliminated that oral evidence is not possible. Then section 61, 62, 63, 64 talk about documentary evidence. We need to keep that also aside and then look at section 65A, which says the contents of the electronic records may be proved in accordance with the provisions of section 65B. So 65A is only a pointer to section 65B, and it qualifies it as a special provision. By stating it's a special provision, it is telling you, please don't look back on the immediate 4-5 sections where we have discussed various types of primary evidence, secondary evidence, when primary evidence is acceptable, when secondary evidence is acceptable. All these things were discussed in 61, 62, 63, 64. All that is not relevant. Now we are coming to section 65 capital A, which is a special provision. And please look at the next section 65 capital B, and that is what this particular section is telling. Now section 61 was telling that contents can be proved either by primary or secondary evidence. But I am saying that you forget that because this is not a special provision for this thing, but just for record I am saying. Then section 62 defined what is a primary evidence. And it said that when the document itself is produced, then you can call it as the primary evidence. But in the electronic document scenario, I told you primary form of electronic document is always in binary form, and it is in something like this memory card. If you take the example of a digital camera, the first impression of digital nature which occurs of an event is the impression of zeros and ones created in the memory card which is attached to the computer. Now at this stage it is a raw data, it is zeros and ones. You human being cannot see what it is. Only when you pick out that memory card, put it into a computer which has got a video reader, okay, then you will be able to view the picture. So the original record is in zeros and ones in a particular sequence, and normally this sequence will also have something called a header information. The header information will say the whatever will be coming after this next point of limitation will be readable in Windows software of something like a video player. This instruction to the device is contained in the header information. So when this memory card is introduced into any particular device, it will first read the header information. There, if it sees compatibility of the application which is there in the computer, then it will be able to read the next few lines then in the appropriate form. For example, if it recognizes this is a video file, it will immediately open a media player and then open it out. But suppose you don't have a media player, then perhaps your system will throw up either some gibberish in another thing, or it will not simply open the file at all. So there is that header information which identifies how to open this particular file. Subsequently, the data gets opened with the appropriate application. That is how the binary data is constructed and first captured when the first version of the electronic document gets created. This is what we can call as the original document. In fact, Information Technology Act uses a term called originator. Originator is a person who first creates a document. If he types it on the computer in his keyboard, that is a text creation. If he is using a mic, then he is creating it as a voice, or he is using this video capturing device called the camera. So whichever is the device which is used, the first capturer is the person who is called the originator, and that first capture is in the device which is used by the originator. and the information gets recorded as a sequence of zeros and ones. If this is a hard disk, it will have zeros and ones in magnetic charge form. If it is on a CD, it will be in the form of lands and pits. So the way it is expressed in the hardware also differs based on what you are seeing. In the case of some device, it will be a rotating platter of a hard disk. In something else, it will not be a rotating hard disk. It is a standard SSD kind of a device with memory cells, and it will invoke. The system of storage of data in each of these things are different, including the file systems, how the name is given, they will all be different. So that is the primary document. In 62, it talks about primary evidence in paper form, because section 65A is the exclusive thing for electronic evidence. Now when you come to section 63, it defines what is secondary evidence. Basically here secondary evidence applies to mechanical reproduction of the original and copies made by handwriting, that is another form. So this sort of things is what is recognized as secondary evidence, not the electronic copies. Electronic copies again are not covered under section 63. Now we have to come back to the section 65A to understand why it was a special provision. So section 64 says that document should normally be proved by primary evidence. Only in some exceptional stages you can use secondary evidence. What are the exceptional cases? That is explained in the section 65. Okay. Now after this section 65A comes and says that now I will tell you the special provisions regarding electronic records. So it doesn't say 65 capital A is a subsection of 65. This is an independent section. So let us forget the other things. Now look at the special provision which is applicable to an electronic record, and that is contained in section 65B. This special provision is necessary because any document in electronic form, whether it is primary or secondary, is not inherently readable by a human being. Court also cannot take a view of its own. Only if they read it along with a device, whatever device says, you should accept it. Even if the judge has got his own computer, if he puts a CD and reads it, he is actually reading what the computer is showing. If the computer doesn't have Kannada font, and if there is a Kannada document called Tirupati, it will not show as Tirupati. It will show as something different. So what the computer chooses to show you depends on what the configuration has been used. So even if the judge has got his own computer, what he sees is not the absolute thing. He only sees something which is relative to the hardware and software he uses. That is why if a judge chooses to view an electronic document and without the help of any other section 65B certifier wants to take a decision on that, then he is becoming a section 65B certifier himself. He should become the witness of the document, which is not warranted. Therefore, every electronic document, even if it is in the hands of the judge in primary form, should be certified by another individual who is trusted by the court and who can become the witness, who can stand in the witness box if required. The judge himself should not become a witness of his own. Okay, so this is one of the principles which we have to remember. Now, so that is why every electronic document has to be produced with another human being providing a written testimony to what this document contains. That is, this person should say, this document says this thing. Why I am saying it says this thing is because when I view it with this kind of a process, that is what I got. And I am not saying anything false. Whatever I saw in my computer is what I am giving as a witness. So that is done by this section 65B certifier, whom we will discuss a little later on. When the judge gets hold of the primary document, remember, he never gets hold of the primary document per se. He gets a trunk, a container. which is a hard disk or even a CD. Even if there is only one file in the CD, it is like one trunk in which only one material object is there. Like, let us say police go and seize a revolver from the house of a particular accused, and they bring the trunk into the court and place it before the court and say, this is the trunk which we have seized from the particular place. And when we seize this trunk, if we open, we see a particular revolver. Okay, so likewise, the document presented in electronic form lies inside the container, which may be a hard disk or a CD, CD-ROM. So what people sometimes refer to as original document. Here is the original document. If somebody says, they are only saying here is the container which contains the original document, and that original document is only zeros and ones. It is not a text, it is not an audio, it is not a video, and human being cannot read these zeros and ones. He cannot experience, that is, it is not a human experienceable document which is there. So you can look at this as a container. So never look at the hard disk as the original. It is only the container of the original document. It can also be a container of a secondary copy. There is a container is a container. You can have the original, or you can have a copy also. You can put it on a CD, or you can bring a USB drive. So there, it may be a copy of the original, but that also will be presented on a container. So differentiate between container and the document. That is not primary and secondary. Primary document is zeros and ones sitting inside the container. Secondary document will also contain zeros and ones. It sits inside another container. So there is no difference there. And to view this particular document, you have to connect this container to an appropriate device, and then whatever the company throws out after conversion, your computer throws out after conversion, that is what you are going to see. Okay. So the concept of primary, this hard disk being a primary evidence should be erased from our mind. These are all some of the things which we have to actually forget before we appreciate 65B. And unless we are able to unlearn this past understanding of evidence, we will not be able to learn. One of the reasons why my views sometimes differ with the views of many experienced legal professionals is, for 20, 30, 40 years, they have been looking at primary, secondary evidence, and they will never understand that there is no primary in the electronic document, and what you see is only secondary. You have to take a view on that secondary, this thing. You can say that the concept of impossibility can be attached to this primary document. The primary document, it is impossible to be presented as an evidence in a court. It can only be put in a hard disk which can be interpreted. Okay, so that is one of the reasons why sometimes my views may look different, but I want you to understand the reason why this difference is there. That is why every electronic document, when it is presented in a court of law, should be certified. Okay, and the certifier say this is what the document means when it is read in a computer with appropriate applications, and that person who provides the certification assists the court to actually render this document. You can call him as an expert if you want, but section 45A has got a definition of an expert. This is also an expert, but may be a lower degree expert. Okay, so this has been recognized and implemented in section 65A, calling itself the special provision. Now we will come to section 65B, which is the center of our discussion. This indicates the manner in which a certificate has to be produced in order to make an electronic document admissible in a court. It is immaterial to discuss here whether it is admissible as a primary document or a secondary document. It is simply admissible as a document. If you look at this section 65B, it simply says it is admissible as a document. It does not want to say it is primary and secondary. Now this section 65B contains 5 subsections. The very first subsection introduces a term called computer output. And this computer output is a reflection of the electronic record, which is the subject evidence. This electronic record is an evidence, but section 65B1 says, convert this electronic record into something called a computer output. And this computer output is admissible as a document if it is produced with certain conditions which are mentioned in this particular section without the need for production of the original. So what section 65B1 says is, we do not need the production of the original. We need production of only a computer output. Computer output is a copy of the electronic record. It can be produced in two forms, one as a printout or as a soft copy. And it has to follow certain conditions specified in 65B 23455. Okay, so that is what section 65B1 says. And all the subsequent sections, subsections 2, 3, 4, 5, they all relate to the computer output. This is one of the important things which are missed by many people, and they don't observe this computer output and then simply jump on to saying that section 65B requires the administrator of Yahoo to come here and give a certificate and all those things. That is all wrong, because we are talking of the computer output and the production of the computer output in a particular manner, and the person who produces the computer output will come and give the certificate. It is not the person who created the original document. The bank manager creates the original document sitting inside the bank. Somebody else views it on a screen and takes a copy. And the copy is being certified by the person who views the original and then gives a copy. Manager need not give the certificate of this copy. So that is the same principle which is used under section 65B capital 1. We will get into the details later. So then second subsection, it prescribes the conditions for producing this computer output. Third subsection recognizes the use of multiple computers, like this computer network kind of a thing, in producing the computer output. Fourth subsection prescribes the requirements of how the certificate has to be produced. And then the fifth this thing gives a recognition that the input to the computer can be given even by automated means. It is not always necessary for the human to give, because the Information Technology Act clearly recognizes that any automated input is attributed to the person who makes it, who presents it. Therefore, even behind every automated activity of a computer, there is always a recognized human being under Indian law, Information Technology Act. There is no artificial intelligence. There is no machine learning. Machine learning is also something which is programmed by the particular individual who has programmed it. Or if you cannot find that original software developer, the person who owns this AI machine, he has to take the responsibility for all AI activities. So Indian law is future-proof in terms of technology, and these people who are developing AI today were not determining what was this law in 1998 or 2000, but our law, which is drafted in 98-2000, included this section 11 in Information Technology Act regarding attribution of an electronic document to the originator, and that sustains us today for the situation which comes in the AI scenario or artificial intelligence scenario. Similarly, the section 65B, the way it is presented, it will survive the quantum computing scenario. Now, some of the judges, some of the legal people may not understand why I am making a statement like this. And right now, the Supreme Court is still looking at this section 65B and may come up with some decision of its own. But they have to remember that section 65B is a very well constructed section. It is the only way electronic documents can be admitted as evidence, and it is always mandatory for a certifier, because that is the nature of the electronic documents. No other way of interpreting this will be considered as correct. I hope Supreme Court will come to a similar decision. Now, some of the things which I say will help you to understand why I am taking this kind of a view. Now, if you look at the evidentiary record, see, the origination of an electronic document takes place, and that is done by the originator. Then it gets into a storage. Then, while it is in the storage, at some point of time in the future, it is observed by the person who will be certifying under section 65B, and it is this observer who converts this electronic record, which is taken out from the storage device, and then before certifying, he converts it into what is called the computer output, puts his signature, and in this sequence, originator need not be the certifier. Similarly, the device in which the original creation takes place is not the device from which the computer output is produced. The original document is created in, let us say, a web server, but the certificate cannot be given from the web server. The certificate is given by my computer where I am viewing this web document. Therefore, the person who originated is different from the person who is certifying. The device which is there containing the original is different from the device from which certificate is being given. These concepts have to be firmly understood before we go into reading the specific sections of 65B 1, 2, 3, 4, 5. Now, if you go into section 65B1, it says, notwithstanding anything contained in this act, which is the Indian Evidence Act, any information contained in an electronic record, which is printed on a paper, which is stored or recorded or copied in an optical or magnetic media produced by the computer, which is referred to as computer output. This term computer output is introduced here, and it refers to the printing on the paper or the soft copy of the electronic record, which is the subject matter of our evidence discussion. This particular computer output shall be deemed to be also a document. It doesn't say it will be also deemed to be a primary document or secondary document. It is simply a document. Don't argue whether it is primary or secondary. It is immaterial. So the section clearly says shall be deemed to be also a document if the conditions mentioned in this section, which is the subsections following, are fulfilled, and it will be admissible in any proceedings without the further proof or production of the original. And it will be the evidence of the contents of the original or any fact stated therein. So it is very clear that what this section envisages is conversion of electronic record into computer output and production of the computer output as evidence subject to the certification conditions which are mentioned elsewhere in this particular section. Now the subsection 2, it says some of the conditions with reference to the computer output. Please see here, conditions refer to in respect of the computer output shall be the following. And what is that? This computer output which contains the information produced by the computer. Which is this computer we are talking of? The computer which produces the computer output. This is not the computer which produced the original electronic record. So the photographer who used the video camera and stored the original in the memory card, that is a different computer. What we are seeing here is the certifier is looking at it in some computer, which is that memory card which has been put into my computer, and we are reading it, or it may be a copy of that memory card, whatever it is. The computer output is being produced by a computer, and that computer, we are saying there is a person who has a lawful control over the use of this computer. It has been used for this kind of a activity in the ordinary course of business, and during the period when I created this computer output, this computer is working properly. It is only for the production of the computer output, which is looking at the computer output in the computer, then taking a printout. Within that time, my computer is working properly. It is not that if I take a statement of bank account for last 10 years, I am not saying that my computer is working for 10 years correctly. My statement is I took a computer output after looking at the statement which appeared on my computer, and when I took the computer output as a printout, which I am signing now, that time my computer in this said period was operating properly. There was nothing wrong in the computer. So this kind of conditions are the conditions mentioned in section 65B subsection 2. This should be recognized as applicable to the process of generating the computer output. You should not link this to the generation of the original document. So suppose you are taking the document from the Facebook, don't tell me that the Facebook administrator is the person who is in the lawful control over the use of the computer. He is irrelevant for me. Now in my computer, I am looking the Facebook page, and that Facebook page is what I consider as appearing in my computer at this point of time. Then I convert that electronic record into the paper form, and that computer output conversion is what I am under lawful control. The third one, as I told you, it is use of multiple computers, a combination of computers used again for the purpose of production of the computer output. Don't again misunderstand this with the web document and other things, because if you say that you have to have the control of multiple computers, you see, for example, a web document, when it comes from, let us say, Google to your computer, when you open a website or something, it comes from the web server and it hops through some 20, 30 routers. Finally, it comes to your ISP, and from your ISP, it gets shown on your computer. In fact, one single page of a web page contains hundreds of files, and sometimes these files come from different routes. HTML file comes from USA via London and lands up here. Then another image file will go to Australia and New Zealand, comes back here. You all know that internet works on the system of packets being sent out and then collected at the destination, and the HTML page contains multiple packets, and any packet can come from anywhere. Therefore, if you say that I want to list all the computers through which this HTML page has been created, you will have hundreds of computers, servers, routers, and if you say all those people have to give me a certificate, that was not the legislative intent of this particular section. What this section says is, all that happened behind the screen, and then some document came and appeared in before your computer. From there you converted into computer output, and that process is what we are taking control, and the person who is converting it is saying that I am the person who is in lawful control of this computer. I saw this electronic record, I gave a control P, kind of a command, then I had a printer attached to it. That printer actually printed out this page, and I am signing that. This conversion from what I saw here to what is printed, that has been done faithfully. I guarantee that. That is what the certifier is saying. So now coming to this subsection 4, it says a certificate has to be given for this particular purpose, and that certificate should contain identity of what electronic document I am certifying. So either as a, you have to list 1, 2, 3, 4, 5. Normally people like us do it as annexures and put all the statements before that and say the annexures 1, 2, 3, 4, 5 are the electronic documents I am certifying. So a list of electronic records with the identification annexure 1, 2, 3, 4. That is one of the things which has to be contained in the statement. Then it has to give the particulars of any devices involved in the production of that electronic record. I have to say that for this electronic record to come and show on my computer, I used a laptop which was running on Windows. I had an internet connection and I opened a browser. In the browser, I typed www something, and then I pressed enter, and then something came on my computer. I have taken a printout of that, and this is the printout, and that is the section 65B certificate document. So that particulars of device used and the manner in which it was produced, that should be part of the section 65B certificate. And this is the most essential part, because the reason why this has to be recorded is, if the court tomorrow wants to check whether my statement is correct or not, they can ask another person to reproduce what this person has said. Please connect it again to your computer, which is also running on Windows, which is also having internet connection, and also type www so and so. Please let me know whether you see the same thing. So reproducibility of what the certifier is saying is ensured by the person recording in his statement the exact process. That is the important part of it. Then the person will sign it. If this is being viewed by an organization, then I have to say I am the manager of this organization and I am signing it. Otherwise, I have to say I am an individual who is signing it. That is all the meaning which is associated with this purporting to be signed by a person occupying a responsible official position. In the case of individuals, I am the person who is an individual, I am the responsible person. So that is how we have to interpret this. So that is, as far as certification is concerned, section 65B5 just extends it to these automated equipments. So in summary, if you see, section 65B states that you are creating a computer output as a reflection of the electronic record, and that computer output can be either in print form or in electronic form. If it is a print form, then you will give a physical signature. If it is an electronic form, you will give a digital signature. Then this computer output is produced by certain methodology, by a certain person, by using certain devices, and all that is regarding how a computer output was produced. That has to be recorded in the certificate. That is what section 65B's other subsections 2 and 3 and 5 talk about. And subsection 4 talks about how the certificate has to be provided. It has to list the documents, it has to list the devices, it has to list the process, and then it should be signed by the person. All these things are the essential ingredients of a certificate. If these conditions are satisfied, then this paper, that is print certificate, is admissible as electronic evidence in lieu of the electronic document which can be brought in the hard disk. You don't require a forensic seizure of a hard disk and bringing it, because Indian law recognizes that when you seize a hard disk, you are not seizing this one electronic evidence, which is a one-page 10 KB say document. You are actually bringing 40 GB, 60 GB of data into the court, which is all irrelevant. There are other confidential material there. You cannot produce it to the court. You cannot give it to the other party as a copy of your evidence. If the other party asks evidence, give him only the evidence objective. But how can you take the evidence objective? That is why this law says, I don't require the original. You please give a section 65B certified one-page document, which is the Word document or whatever is the evidence. That we will admit as evidence. And if the other party wants copy of that, give it. If you give the entire hard disk, then it requires a seizure kind of a authority. If I say that there are other evidences in the same hard disk which I have to search, then you have to ask the court to give you permission to conduct a search, and therefore the search warrant should be for the other documents which are there in the hard disk. So any forensic person who is trying to apply forensic principles will have to have a summons or a permission from the court to do a forensic investigation, which means discovering the evidence which is not likely to be there, and therefore there could be confidentiality and privacy considerations. So all these things are issues which I am putting out as technical issues. So section 65B is trying to marry the techno-legal nature of this evidence and trying to give you the right kind of solution. Now I will give you a few cases in which how this has been used. The very first case in India where the Section 65B certificate was issued was Suhaskati case. This was in an assistant magistrate court in Egmore. But even to today, this remains the historical case of first conviction under Information Technology Act. In this particular case, the object of crime, which was a statement made in a Yahoo group, was the material, and that whatever he had written there was alleged to be an obscene document against a lady who had given a complaint. So in terms of evidence, we had to show that there exists a document which contains these obscene words or defamatory words, and that document is originated by this accused, and it creates a harm to this victim. Therefore, we want him to be punished under Section 67. So for this particular thing, this document had to be brought to the court as evidence. For obviously, in this case, the police could not go to New York and snatch the hard disk of Yahoo group and bring it here. It was an impossibility. Instead of that, they asked me. I sat in my house, opened my browser, opened Google, Yahoo.com, went to groups, went for this particular message and showed it on my, it came on my website, my computer. I took a printout and gave a Section 65B certificate. So this became the first case of Section 65B certificate being used to bring an electronic document in a remote, far-off server into the court. This principle today means that any cloud storage document can be brought to the court without the cloud hard disk being brought there. Immediately after this 2004 there was another case called Trisha case, which did not go into the court records, but it is important for students because in this Trisha case of defamation, the court had a CD in its hand, and the police had seized that CD and produced it as an evidence of crime. Now, the judge had the option of putting that CD in his computer and viewing it and taking it on record. But this judge, Magistrate Arul Raj, who is perhaps not a celebrated judge as of today like a Supreme Court judge, but he took the most correct decision at that time, saying that though I have got the CD in my hand, what we want is to view this primary document which is there inside the CD, which I don't want to do it myself. And he called me as a person, external person, who would view that in his chamber and then convert it into printouts and then give my signed report on the printout, which is accepted as evidence, and he went ahead with this trial. This established the situation where a judge should not opt to be a certifier. Okay, so this was the critical aspect of this Trisha case. Subsequently, in 2005, we had this famous Afzal Guru case, but in this Afzal Guru case, Supreme Court allowed the admission of electronic evidence without insisting on the certificate. Therefore, from 2005 onwards, many people said this is the precedence of the Supreme Court, and therefore that this Section 65B certificate is not mandatory. They forgot that the Act said something else, and the court perhaps had made a mistake, but that remained as a judicial precedence until 2014 in the Anwar versus Bashir case. The Supreme Court for the first time made a critical analysis and said admissibility is different, genuinity is different. At the time of admissibility, Section 65B is mandatory, and oral evidence is not acceptable, as it was done in Afzal Guru case. So it was stated that the procedure used in Afzal Guru case was not correct, and then that became the law. Subsequently, there was another interesting case, which was Tiwari versus Arjun Singh, where this question of an electronic document being recorded in the video camera and then stored in one place, then that is restored in another place, and you ask the election commission or somebody to give you a copy, and they will take from their server and give it us. They already have a CD submitted by that videographer. From that CD, they will make another CD and give it. So in such cases, they need to have what is called contemporaneous certification, where at each stage of transfer, one Section 65B certificate has to be set. The first person will say, this is a Section 65B certificate. I am saying that this memory card, I converted that image into a CD. Then next person will say, from CD1, I created CD2. I give my Section 65B certificate for that. Like that, for each stage of conversion, a Section 65B certificate has to be given, was established in this Tiwari versus Arjun Singh. Sonu alias Samar case was actually regarding the retrospective effect. They did not want to open old criminal cases because Section 65B certificate became mandatory according to the Supreme Court only in 2014. And there was a criminal who had been convicted. He filed a case for revision of his conviction, saying that the police have not submitted Section 65B certificate. So in that special context, this particular Supreme Court said that we will not revisit this case, like it will be treated as a special case. The last is a very important case. In 2018 January, there was a Shafi Muhammad case in which a two-member bench of the Supreme Court overruled the three-member judgment of the Bashir case and said, we are going to interpret what this three-judge bench has said, and according to us, it is not mandatory to have Section 65B certificate. And they made a distinction that if the electronic record is in a device which is in the possession of the person producing the evidence, then Section 65B certificate is required. If this device is not in his possession, Section 65B certificate is not required, which meant that in cases where the presenter of the evidence had a device which he could place before the court and said, here is the original evidence, please look at it yourself. In that case, this judgment said, you need Section 65B certificate. But when I say I've taken a printout from somebody else's computer, and I say that was not my computer, it was somebody else's computer, but I'm producing this printout, please accept it without Section 65B certificate. It was a ridiculous judgment saying that Section 65B certificate is not required when the device is not in your possession. It is required when the device is in your possession. However, it was a judgment of the Supreme Court and an SLP. Basically, it was a case where the police wanted some kind of a leverage to actually have photographs of the crime scenario. So that was a very special occasion. Court perhaps wanted to favor the police. They gave that judgment. Now that judgment has now been again referred to a larger bench by the Supreme Court itself. And that is now pending before the Supreme Court. I think a couple of hearings have happened, and a lot of people are trying to manipulate this judgment to ensure that somewhere we will make the Supreme Court declare Section 65B certificate is not mandatory. And we are waiting to hear what the Supreme Court comes out with the decision. But my particular, whatever I have been talking for last 1 hour, I am sure that I have made it very clear that Section 65B has a purpose, and it cannot be and it should not be changed the way it is being drawn. Okay, and I would like all the experts here to also explore further on this cyber evidence thing through my website ceac.in. It is called Cyber Evidence Archival Center. I've got something called an evidence drop box which explains why this kind of certification is essential in our e-commerce scenario. So if you just want to summarize, you have to understand that Section 65B has got a reason to be there, and we have to support that. And for more information, if you want, please visit this site ceac.in. Also, my site avi.org also has got links. There is also an ebook on this Section 65B where I have tried to explain. Okay, now I will take some questions if it is there. I have not left much time, some 10 minutes at least. I don't mind spending more time. Yeah, I will just see if there is anything. No, in the chat, nobody seems to have put anything. So, any other questions, either from the principal side or from the lecturers who are there, are welcome. Anybody who has raised his hand? There is one Rahul Raghav. He wants to say something. Rahul Raghav. I think, yeah. Rahul Raghav has raised his hand. So no questions. And Dr. C. Narendran Chandrasekharan, please unmute yourself before you speak. And Rahul has unmuted himself, so if he has got something, he can speak.
Hi sir, now I'm able to hear you. First of all, I just wanted to thank you for your, the fantastic presentation. I just wanted to understand your previous experience since you have been working in this field for more than the 3-4 decades. So, in your experiences, have you come across like a situation like based on your submitted evidences or I mean certifications in the court
Hello.
with the help of 65B?
The session is open for question and answer. If anyone has any questions,
I
please
think Doctor is
go
already
on.
asking the question. Yeah. Go ahead.
All right.
Yeah.
So my question is, in your experience, you have submitted and certified a lot of the digital evidence in the court with the help of the
Yes,
section
Rahul Raghav.
65B. So is there any situation have you come across like the your certifications or the completely broken by the defense party? Like you have based on your the broader analysis and on top of
I have
those.
submitted more than 138 certificates so far, starting with Suhas Khatib case. Most of these cases are on sometimes on copyright violations on website kind of a thing, and also on matrimonial cases. Unfortunately, most of the time the defense lawyers, one, they have not been able to break this, and also there is a reason. See, when I stand there as a Section 65B certifier, okay, not as an expert witness. In the case of Suhas Katti, I was an expert witness. So you could have asked any questions you wanted and try to break my theory or whatever is that. But when I produce this Section 65B certificate, the only thing the other party can ask is, first of all, whether you are the person who has signed this. Yes, I am the person. And now any questions they ask will have to be on that document which would have been submitted. Normally, this document is submitted at the request of one of the parties to that person, and that person under his affidavit will submit it to the court. It comes for evaluation. The other party perhaps may dispute it. At that time, I am called as a witness. The first question is to say that yes, I am the person who has given this. Okay, that is simple. The second, this thing is, if they raise any questions, normally I will say that, see, if this report is to be questioned on admissibility, then you have to tell me whether it is not signed by me, whether I have not listed the electronic documents, whether I have not listed the devices which I have used, whether I have not listed the process in as simple a manner as possible. Those are the 4 questions you can ask. If nothing that is answered, if all of that is positively answered by me, the question of admissibility is over. Now, this document has to be admitted and marked. Now, next question is, you want to say that this is not genuine. Genuinity can be questioned on 2 grounds. One, you may say that I have manipulated and given a false evidence, in which case you are actually charging me on perjury. For this purpose, I always try to establish in my report itself my credentials so that the judge views who is giving the certificate, and then he makes a decision of my credibility separately. Okay. Then second is, I would have given a report saying that on such and such a day, at such and such a time, when I viewed a particular electronic document, it was like this. Now, today, if you go there, it may not be there in certain cases, or it may look different because the person in charge of it could have changed. I have no control on that. So my Section 65B certificate does not get affected because somebody else changed it. Then your question of whether my certificate was genuine or not stands. The court has to take a decision whether it is possible that my certificate is still valid, because it is possible that on the day when I visited, whatever I have stated is okay. Then if subsequently it has been changed, it may be due to some other reasons, then it is for the court to either accept or reject that situation, or ask that other person to, in fact, the other person when he counters, he has to bring another Section 65B certificate only. That person has to say when did he view it. If he has to say that he viewed at the same time and I have viewed and it is different, then only there is a clash. Otherwise, I am saying this was what was there yesterday. You are saying something was there today. It is possible, so that cannot be questioned. So most of the time, this cross-examination cannot be done to beyond just inquiring how this certificate was produced, most of which I would have already written in the certificate also. So don't expect that there will be a sort of a fight between the witness and this, because I am not an expert witness. I am not going to give any opinions. I am only going to state facts, that when I visited, this was the fact. Now you tell me whether my printer was working or not. If you want to ask a question, you can ask that question. You can ask the question that your printer may be having a black and white print, ink, and this was a color document. You might have missed. Yes, that is a question you can ask. I am saying no, I use the same thing, whatever was required. Beyond this, it is not possible to have a kind of discussion which you will be having with an expert witness who comes in the forensic witness. If a forensic person comes, then I can have a cross-examination, questioning his method, etc. Here, there is very little scope. So, in the more than 100 and odd cases which I have given, I don't know how many of those cases finally reach the table of the judgment. And in a few cases where I have gone and stood there as a witness, basically the questions have been very peripheral. Sometimes people come with a lot of aggression to say that you are not a lawyer, how can you give this certificate? I am saying computer is not law, computer is electronics. I was an electronic graduate and I was the person who created this whole system of cyber law education before anybody else. So there was no possibility of my going to a college and getting a certificate in the year 1998-2000. So courts normally respect an expert, and expertise is not only through degrees. So this is the only question. Sometimes it's embarrassing when they ask such questions, but beyond such small embarrassment, there has been no threatening cross-examination so far. I don't think it will be there in future also, because the objective of Section 65B is very, very limited. It is like asking a photographer. I am saying I have taken the photograph, I have given it. Only ask me whether I have taken the photograph. Yes, I have taken the photograph. What camera you have used, I can tell me. If you want to ask me about technology of camera, I am not supposed to give that as an evidence here. I am only giving an evidence as a photographer. Okay? Am I making my limitations clear? Parth Chauhan asked this question. Section 65B certificate will be produced multiple times for the same evidence for multiple proceedings for days, or there will be only one Section 65B certificate. We normally give, for example, if I give a printed copy, that printed copy will be used by them and they can use it any number of times. Sometimes when things are to be produced in two different courts, I will try to give two original copies, that is copies on which my personal signature is there on every page or something like that, just to facilitate the litigant to produce one in one court and another in another court, instead of getting a certified copy and produce elsewhere. But actually, one copy is sufficient, and further copies you can take certified copies from the court itself, produce it in court, get a certified copy and use it elsewhere. But I try to make things easy for people to, by producing, giving two signed physical copies. Sometimes I also give a soft copy. In the case of videos and audios, it will be essential to give a soft copy because you cannot capture the entire video on the paper. On the paper, I can only give the hash value of the video document. I will also give some screenshots of the video when it is played at 1 minute, 2 minutes, 5 minutes, 10 minutes, something like that, just to indicate that this file is same as this file. But the full file has to be there only in the soft copy. So in the case of audio and video certifications, the certificates are normally issued in the soft copy form. Okay. What if an error occurred? Will you be able to certify? It depends on what is the kind of error. Say, for example, there was one case in Bombay, Shapurji Palanji e-tender case. Okay, most of these things in detail, you can see it in my website. In this Shapurji Palanji case, what happened was, it was an e-tender, and Shapurji Palanji as a company had tried to apply for the tender, but somehow the NIC, which had considered the tender, said that they have not received your tender application. So without considering Shapurji Palanji's application, they considered the other applications for shortlisting. So this company challenged that in the court, saying that I have submitted my tender, but the tender committee has not accepted my application. When this came to the court, the NIC people said that we have not received. Then Shapurji Palanji people said that we uploaded all the documents and upload was successful. Therefore, we think that we have submitted the document. Then the NIC people said that there was a procedure that after you upload all these things, one button should come where you should click submit or something like that. Now the Shapurji Palanji lawyer said that no, we have not received that. We did not see that button. There was nobody to prove or disprove. It was perhaps there and they forgotten or something like that. Or there was an error also, we don't know. Now, when this came up, I gave, of course, this was post the issue, I gave only my academic viewpoint, not in the court or something like that. I felt that in such situations, the error also has to be proved to the court that when I tried to upload the tender, I did not get this particular page where submit should have been there according to the defense. How do you prove that? You should actually have a video recording of your upload process, and you should have got a section 65B certified copy showing that after the last upload, then the screen went blank. If you had shown me that, I would have accepted it. Otherwise, I would not have accepted the evidence. But in this particular case, court somehow condoned this process and said that after all, we are still in the first stage of, considering the prospective tender applicants. So qualification stage. Therefore, they said there is nothing wrong in adding this party also into the qualification stage and gave the decision in their favor. But that was a case of an error which required a certification of the error. It can be done. If there is a bug in the software, if it is trying to show something else, if you want to take a legal action on that, yes, it has to be section 65B certified. Yeah. Organizers have the right to close it whenever they want, but if otherwise, if people have questions, I am willing to answer the questions. Any other question? Yeah, Madam Mamta, you have any questions?
Yes, sir. Sir.
Yeah, go ahead. You have opened two computers nearby. That's why they said, okay. Yeah. Tell me. An experienced teacher like you, I want your opinion and questions on what I'm saying. Yeah, use one device, then only it will come out properly. Yeah, Samiksha, you have got anything? Yeah, no questions?
Participants, if you have any questions, please put on or raise your hand so I can unmute you.
Yes, sir.
Yeah.
When there is a collision between two laws, evidence as well as this Information Technology Act, which would prevail, sir?
You have to give me exact, what is the collision, then I can answer. But
No.
electronic evidence definition flows from Information Technology Act,
Yeah.
and amendments to Evidence Act was also caused by the changes in the Information Technology Act. So if there is a doubt about the interpretation, ITA 2000, about what is an electronic evidence and all these things, ITA 2000 should prevail. Okay. Other than this, you have to tell me exactly what is the collision you are talking of, then I will give my viewpoint. This secondary evidence, primary evidence, I have tried to explain that technology can only interpret the way I am talking of. So the fact that there is no second primary evidence which can be brought into the court, that is where you may say that there is a clash. And in this some of these court cases also, they have said 62, 63 is also applicable. 65B also is applicable. That will not happen. It is not a correct judgment. You cannot have this concept of primary documents in the case of electronic documents. If that is the conflict you are seeing, I feel that there is actually no conflict. It is actually an improper interpretation of section 65B.
Yes, sir. Thank you.
Okay. I know I am challenging a Supreme Court decision, but I have the confidence to say that what I am saying is correct, even if judge says something different. Judge can always have his own view. I am not a judge. Okay, but my views will prevail. In 2005, when this Afzal Guru case came, many times when I interacted with senior police officials in NPA, they keep on telling me that, sir, you are saying it is mandatory. Supreme Court says it's not mandatory. I always said that that was in a different context, it is not applicable. So likewise, even after Shafi Muhammad case, I said it is a wrong decision. My views will remain because I feel that it is based on what is written presently under Section 65B and how it is practical to take the kind of interpretation I am giving. If tomorrow, if Information Technology Act changes, or if the Supreme Court wants to read down, like they did in the case of Section 66 capital A, which was also a wrong reading down, according to me, it will be still be acceptable as the law of the land. Okay.
Fine, sir. Thank you so much for your wide interpretation. Thank you.
Sir,
Thank you.
Sir, this is Poonam Singh. Are you able to hear me, sir?
Yeah, I can hear you. Please go ahead.
Sir, there is so much of internet issues, so I don't know whether you have explained about that or not. I have a doubt that what is the role of cyber forensic in legal term?
See, cyber forensic is an expert who is trying to, first of all, discover an evidence which is not apparent. Say, when you undelete the deleted file and other things, is it not? That is one of the forensics. Then he goes into the system files and other things and gives an opinion about an electronic document. So he is an expert who gives opinion on the incidents, whereas Section 65B certifier does not give any opinion. It's a matter of fact certification. That is the difference. Okay.
Okay, sir. Okay, sir. Thank you so much, sir. Thank you.
Yeah.
Hello, excuse me, sir.
Yeah.
Sir, we have reported many call list cases and another things in daily routine, sir. Tracking a call record of when it comes to where what is my question is that it is some will decide, or some will object that taking my call list or WhatsApp list is an offense. It's defends my private. It is my private. So, but police says that it was essential. What's the role of legal or expertise?
See, this is not an evidence related question, it is a privacy related question. Say, privacy is there, but the law enforcement has got certain powers which they can use as exceptions. At present, the privacy law is only section 43A of Information Technology Act. Even when the Personal Data Protection Act comes, law enforcement will continue to have some powers. Now, if the law enforcement misuses the power, you can challenge it in a different way, that they are misusing the power. But if they have got, let us say, a case on hand, a complaint on hand, they have registered a crime, and under CRPC they are asking for some information, they have got the right to ask that information. Okay, privacy does not come in the way, because privacy is subordinate to these special rights for law enforcement for investigation of a suspected, let us say, crime activity. Okay.
Thank you.
Yeah.
Sir.
Yeah.
Sir, I'm going to talk on the ongoing issues in the India. The people, the politician will give the very hard type of speech in front of the people, and people will record it and all. And sometimes it will be questionable. I can name them if it is required, but that is not going to stand in the current scenario. Why it is? Because, sir, he would have.
When you say it will not stand, it will stand. The only thing is, whatever he has stated, whether it constitutes defamation or not, there may be opinions or there it may be different. If he is saying something fact cannot be questioned on defamation basis. But if he is saying something which is wrong, people do file defamation cases, and when defamation case is filed, this recording will be an evidence, and that evidence has to be section 65B certified to be admitted, and it will be admitted, and the court will say, this is what we are seeing here, this is what you have said. That for that purpose, that evidence will be there. Then what he said, whether it is defamatory or abusive and other things, is a matter of subjective interpretation of the content of an electronic document, which the court will do. Sometimes they withdraw the case afterwards for various reasons, but if it is defamatory, if a false statement is made, definitely there is a possibility of that is an IPC case. Say, case is filed under IPC, but evidence is electronic, so it is not a cyber crime. It is actually a defamation committed with the use of electronic documents, and like you do it in paper, you are doing it in electronic documents. Evidence alone will be electronic. To that extent, you have to invoke the provisions of section 65B.
Okay, sir. Thank you.
Yes, sir. I hope we have come to the conclusion part.
Okay.
Yes, sir. Please.
Thank you. Thank you.
For all the questions. Yes, sir. I hope you wanted to wind up the session, and we have come to an end of the program. I would like to, with your permission, I can proceed with a vote of thanks. And it was a very engrossing, insightful session, having focused on all historical precedents of the Apex Court. We would like to really applaud and appreciate you in this regard. And you said you are not a judge. Nevertheless, sir, really, you are a really, eminent jurist. That's what I can use the term.
I call myself a cyber jurisprudent. Okay.
On behalf of C Group of Institutions, especially C Law College and Clue for Evidence Foundation, we heartily extend our special thanks and gratitude to the eminent speaker, Vijay Shankar of the day, who is an eminent speaker of the day. Thank you so much, sir. I also personally thank Mr. Phanindra BN, the director of Clue 4, for having accepted to host this issue jointly. Thank you. I also thank our management for their constant support in this regard. Thank you, one and all. Thank you, all the participants, for having made this event as a grand success. Thank you. Yes, sir. Thank you, sir.
Thank you.
Have a nice day. Thank you for joining us.
Thank you, sir. Thank you, ma'am. And this is the end of the sessions. Participants will receive their certificate soon, and we'll see you in the next session. Please be connected with us for the upcoming sessions. Thank you.
Thank you, ma'am.